a quiet, private home, a domestic space operating under the assumption of peace. Then that peace is shattered. Cleveland, Ohio, May 1957. 3 police officers arrive at the residence of Dalry Mapp. They suspect someone connected to a recent bombing is hiding inside, alongside illegal gambling paraphernalia. Mapp demands to see a search warrant and refuses to open the door. Hours later, the police force their way inside, breaking the glass to gain entry. As the officers swarm the hallway, Mapp again demands the warrant. In response, one officer holds up a folded piece of paper. She snatches it and shoves it down her dress. The officers grab her, twist her arm, place her in handcuffs, and retrieve the paper. That piece of paper is never produced at trial, but during their widespread search of her home, the police find a trunk in the basement containing obscene books and photographs. Mapp is arrested and convicted for possessing those materials, a crime entirely unrelated to the bombing investigation. This sequence of events sets up a severe legal paradox. The police violated the law to search Mapp's home, but the state seeks to use the evidence they stole to legally convict her. The framers established a strict constitutional boundary to protect citizens' private domestic spaces from government intrusion. To legally cross that threshold, police generally need a warrant, issued by a judge based on probable cause. But when officers ignore those rules, it forces a question. If a state obtains evidence unconstitutionally, can it still submit that evidence to a jury? The answer depends entirely on the distinction between a substantive right and the remedy used to enforce it. A right the government can violate without consequence at trial is an illusion. It is a right in name only. In 1914, the Supreme Court established a strict boundary for how evidence is handled in federal trials. They held that evidence obtained in violation of the Constitution cannot be used in a federal criminal trial. But the vast majority of criminal cases are handled by state courts, not federal ones. In 1949, the court addressed those state systems in Wolf v. Colorado. This diagram illustrates the doctrine of selective incorporation. In Wolf, the court ruled that the core substantive right of the Fourth Amendment, the security against arbitrary police intrusion, does apply to state governments through the Due Process Clause of the 14th Amendment. But they attached a critical caveat. The court defined the exclusionary rule as a judicially created remedy, not a strict constitutional command. Therefore, states were bound by the right, but free to enforce it through alternative remedies, like internal police discipline or civil lawsuits. This created a sharp jurisdictional asymmetry. Federal courts suppressed illegally seized evidence. State courts did not. The resulting system was highly unstable. Federal prosecutors even used evidence illegally seized by state officers until the court abolished that silver platter doctrine in 1960. By 1961, the theoretical architecture of the Fourth Amendment was fractured. State-level privacy rights depended entirely on alternative remedies that proved largely illusory in practice. In a landmark 1961 decision, the Supreme Court completely alters the landscape of local criminal prosecutions. The ruling directly addresses the glaring omission left by prior precedent, finally giving teeth to the constitutional promise. Writing the principal opinion, Justice Tom Clark collapses the distinction between the two. He argues that the exclusionary rule is not an optional enforcement tool, but an essential ingredient of the constitutional guarantee itself. Clark argues that without an enforcement mechanism, the constitutional guarantee is nothing but an empty promise. Beyond the text of the amendment, Clark relies on a second rationale: judicial integrity. The courts have a duty not to sanction unlawful government conduct. If a judge admits stolen evidence, the legal system becomes an accomplice to the lawless police action that produced it. Clark warns of the catastrophic institutional damage that occurs when the justice system turns a blind eye to illegal police conduct. Looking at this breakdown of the 9-seat bench reveals a fragile consensus. 6 justices vote to reverse the conviction, but Clark's Fourth Amendment logic only commands 4 votes, a plurality, not a majority. Justice Black supplies the 5th vote for the exclusionary rule, but he doubts the Fourth Amendment alone requires it. Instead, he supports the result by combining it with the Fifth Amendment's protection against self-incrimination. Justice Stewart provides the 6th vote for reversal, but he decides the case purely on First Amendment obscenity grounds, declining to reach the search and seizure question entirely. The court successfully delivered a remedy to Dalry Mapp. But the fractured mathematical consensus left the exclusionary rule's theoretical foundation highly vulnerable to future challenges. Those challenges are laid out in a sharp dissent by Justice John Marshall Harlan, joined by Justices Frankfurter and Whitaker. Harlan begins with a severe procedural critique. Mapp's lawyers briefed and argued the case primarily as a First Amendment dispute over the obscenity statute. The court reached out to decide a massive Fourth Amendment question the parties had not squarely presented, an abandonment of judicial restraint. On the merits, Harlan raises a profound federalism objection. He argues the Constitution demands uniform national rights, but permits diverse state-level experimentation regarding how to enforce those rights. He then addresses the practical social cost of the majority's new national mandate. Suppressing reliable evidence often means guilty individuals escape justice simply because the police made a procedural error. Harlan echoes a famous warning issued decades earlier by Justice Benjamin Cardozo in a New York State case. Harlan echoes a famous cost objection, warning that society suffers when procedural mistakes let criminals walk away. The dissent frames this not as a debate over whether police should obey the law, but as a structural dispute over how much power the federal judiciary has to dictate remedies to state courts. In the decades following the 1961 ruling, the Supreme Court systematically dismantles the philosophical core of Justice Clark's opinion. Later courts abandon the idea that the exclusionary rule is an essential constitutional right. They recast it as a judge-made device to deter police misconduct. It becomes a balancing test. If suppressing evidence won't change future police behavior, the rule is bypassed. This new logic drives United States v. Calandra in 1974 and establishes a major leeway for police a decade later, which admits evidence seized by officers reasonably relying on a defective warrant. Further modern narrowing follows. In Hudson v. Michigan and Herring v. United States, the court declines to suppress evidence resulting from knock-and-announce violations or isolated police negligence. Whether the exclusionary rule actually deters police misconduct and whether its costs are justified remains a highly contested empirical debate in modern criminal law. The landmark Mapp decision imposed a mandate that survives today, but its philosophical soul was entirely hollowed out and replaced. The Fourth Amendment guards the physical boundary of the home against the power of the state. The Supreme Court has spent the last 60 years negotiating exactly how much protection that promise requires, and how much enforcement the system can bear. Ultimately, the true power of the Constitution lies in how it is actually enforced.